My name is Caroline Parker, and I'm a current fellow at the LPE project, here to welcome you all. Thank you for joining us. As you know, we had hoped to gather in person last April for the Democracy Beyond Neoliberalism conference. Thanks to the patience and resilience of this community, we are thrilled to be hosting our series of conference panels virtually instead. Our entire lineup of events and registration links, as well as a sneak peek at the upcoming blog symposia, are available through our website, lpeproject.org, where you can also sign up for conference-specific updates and reminders. Our next event, titled Transforming Private Control Over Political Production, which will examine institutional barriers to democracy, will take place tomorrow, March 18th at 7 p.m. Now it is my pleasure to introduce today's student moderators for the event. Danica Gallup is a second year at Brooklyn Law School, and after working in social work for several years and observing the harms of the child protection system, Danica decided to pursue a career in family defense and criminal defense. Xinxin Zhou is a second-year student at Brooklyn Law School as well, working towards ending racialized cycles of punishment and control. She hopes to use her legal education to build healthier communities where families can thrive.
Hi, everyone. Thank you so much, Caroline, for those introductions. As Caroline mentioned, my name is Danica, and Xinxin and I will be co-moderating this discussion. Thank you so much first to the LPE project for putting on this panel, and of course, thank you in advance to our panelists for what I know will be a very robust and poignant discussion on the political economy of motherhood. So before we get started, I'd just like to provide our audience with kind of a rough outline of what the next hour and a half will look like. So first, I will give a brief introduction of our panelists. And next, the panelists will each speak on their work and research. And after our panelists have each had a chance to present, Xinxin will facilitate a conversation between the panelists. And finally, to wrap up, there will be a Q&A session for the last 20 minutes or so of this event, which I will moderate. Audience members, please feel free to use the chat function or the Q&A function to type in any questions you might have at any time for our panelists. And the panelists could address these questions directly in the chat, or I can pull them out during the Q&A portion of the event. So without further ado, let me introduce today's panelists to you. So first we have Wendy Bach. Professor Bach is a professor of law at the University of Tennessee, Knoxville, where she represents children and families through UT's clinical program. Her research focuses on the interaction of welfare systems and systems of support or care with systems of punishment in poor communities. Next, we have Cynthia Godsoe. Professor Godsoe is a professor of law at Brooklyn Law School, teaching family law and criminal law. And her research focuses on the legal regulation of intimate behavior and gender roles. Next, we have Julie Suk. Professor Suk is a visiting professor of law at Yale Law School and professor of sociology, political science, and liberal studies at CUNY. Her research focuses on equality at the intersection of law, history, sociology, and politics. Her scholarship also emphasizes comparative constitutional law and the procedural implementation of equality norms in both the US and Europe. And finally, we have Jessica Dixon Weaver. Professor Weaver is a professor of law at Southern Methodist University Dedman School of Law, where she is the 2020-2021 Robert G. Story Distinguished Faculty Research Fellow. Professor Weaver's current research focuses on the explication of family formation, regulation, and dissolution of African-American families and white families during slavery. So briefly, let me turn it over to Xinxin.
Thank you so much for those introductions. So now we're just going to move into a time of some individual presentations from our wonderful and esteemed panelists. And to kick us off for tonight, we're going to have Professor Bach speak. And so whenever you're ready, Professor.
Okay, I am just going to share my screen. There we go. So in our time together, I'm going to talk to you about a book project I have been working on and I'm almost done with. The book is entitled Decriminalizing Care. And the book focuses, please work, okay. on the prosecution of about 120 low-income, mostly white, mostly rural, but also some urban Black women in Tennessee between 2014 and 2016 for the crime of fetal assault. Fetal assault was a crime in Tennessee. It was an A misdemeanor. And during that period, in utero transmission of narcotics resulting in harm to the fetus was an A misdemeanor assault. The problem, as framed by those in the legislature and in the legislative hearings, that they were trying to solve by creating this crime was framed around neonatal abstinence syndrome, or what I'll refer to as NAS. NAS is a short-term treatable but quite acute condition that infants can suffer as a result of being exposed to a variety of medications during pregnancy. There was at the time a spike in NAS cases and quite a lot of concern around it. And so the legislator decided to create this crime to address that problem. One of the things that drew me in to this very long project of mine, looking at these prosecutions, was that in addition to quite standard justifications for the creation of a crime, retribution, things like that, there was a really, really sharp hypothesis in the legislative record and in the sort of support for the bill about the relationship between the creation of the crime and opportunities for care. So as one delves into the legislative record, you see over and over this idea that prosecution will lead women to care and bad mothers will become good mothers and rescue nice white babies. And all of this will work in a very particularized way. And prosecution was not only sort of a road to treatment spots in the ideas of the supporters, but it was sort of a form of treatment itself. And so this is something that I think characterizes our punishment and care systems in low-income communities. And it was a particularly sort of sharp example of that, which is why I delved as far in as I did into these prosecutions. So there's a lot of stuff in the book. I'm going to take you to some of what the questions and answers that I am coming to as I look at this data. And the first question I'm going to take you into is, how did a combination of stigma and stereotype on the one hand, and then an interlocking systems of laws, policies, practices, legal and organizational structures draw women into punishment systems during these prosecutions, and really in the sort of larger systems in which the prosecutions were located? And then what happens to care, right? If the legislative hypothesis, the care hypothesis, was that somehow this was going to be an opportunity for care, like what does that really mean? And what does it mean to offer care, in this case, medical treatment, proximate to or inside punishment systems? So I want to take you to, I'm going to share some data. This is a very standard petition. Most of them look a lot like this. We pulled all the criminal court files over a couple of years of digging. And what I want you to notice as you look at this is the enormous amount of medical information in this criminal petition, right? So everything I've highlighted in level, right? In yellow, she told the staff that she'd been taking Suboxone. She didn't have a prescription for it. She tests positive for Suboxone. There we have the umbilical cord testing results. We have testing in the medical setting. All of this is presumptively confidential information that flows out of the healthcare system into the child welfare system and ultimately into the criminal system, resulting in prosecution. And when these files started to arrive and we started to see that, it really started to asked me to ask these systemic questions about how the heck this was happening on such a scale. So there are a variety of rules, practices, processes, all of which do two things. One is an enormous sort of wide open door as a matter of practice around protected health information, right? And not just the rules, which I'm happy to talk about in the Q&A, but the practices. So I had a conversation with prosecutors, several prosecutors, and every single one of them was like, oh, hospitals are so cooperative with us. I was like, great, right? Like it was far beyond what the rules say, right? This level of cooperation. But the flip side of that was really the legislative care hypothesis. So despite what I might want the world to be, the on the ground reality was that care was accessible in this sort of environment of precarity, in an environment where there's very few care opportunities. It is in fact true that this is how you access care. So I want to introduce you to a woman I'm calling Cindy Jones. Cindy Jones was a drug treatment coordinator in a rural eastern Tennessee county of Appalachia. Unbelievably resource poor community. And all these people in the county kept on saying, oh, you got to talk to Cindy. You got to talk to Cindy. She's the one who knows how that works. So we get out in our cars, we go talk to Cindy and we say, how do you get people treatment in your county? And she says, lock them up, clean them up, start them over. Right. So her on the ground reality is that's the road to care. The second person I want to talk about is a guy named Stephen Lloyd. Stephen Lloyd was the medical director of substance abuse services in the state of Tennessee from 2015 to 2018. He and I had this conversation, and Stephen Lloyd knows this system better than anyone I talked to. And when I asked him about access to high quality care, this is what he said. Even knowing what I know, if I needed somebody in treatment that didn't have insurance, I told them to go to Greene County and get caught shoplifting. They'd get into drug court and they would get them treated. Right. So the care hypothesis, although from a sort of pie in the sky criminal law theory that crimes are for, right, retribution, pick your rationale, they weren't wrong about the care hypothesis, which is quite disturbing. The next piece that I just want to briefly talk about is the price of care. There's a lot of data around problem-solving courts and the risk you take, the cost you pay. There's a lot that I'm happy to talk about at a different time around care as surveillance in the interactions between medical professionals and the women. But what I really want to focus on as I close is corruption of decision-making. And when I'm talking about decision-making, I'm talking about a woman in a situation making a difficult medical decision with her doctor. And I want to take you to one of those. So you need to know just a little bit of medicine here. So neonatal abstinence syndrome, I told you what that was. One of the hardest decisions a woman faces if she has substance use disorder and becomes pregnant is whether she goes on maintenance medication during the course of her pregnancy, which is what the American College of Obstetricians and Gynecologists recommends, or whether she attempts to detoxify. I can tell you, I have read all the medical journals, I've talked to lots of experts, I have no idea what I would do because there are very serious risks all around in this decision. So it's an important decision, a crucial decision for her health, for the baby's health, for the family's health. But what I found as I talked to folks was that punishment systems, right, that care proximate to or inside or at the threat of punishment was affecting that care decision, right? And there was pressure from, what Stephen Lloyd called practicing medicine without a license, judges, child welfare officials, everybody and their sister, having an opinion about what she should do and systems that would impact her differently depending on her medical choice. So here's Judge Dwayne Sloan. He's a problem-solving court judge in Eastern Tennessee, presides over a court that is a problem-solving court for women in this situation. He said to me early on in my research, Dr. Craig Towers, who's a controversial figure in this research field, he's at UT Medical Center. He just published a study showing that you can take a woman, if we can get them below 5 milligrams at delivery, there's no NAS, right? Which is Judge Sloan's goal. The child will not be in the hospital, no suffering. If it's going down gradually, it's hard to know the in utero trauma, but it's just like with a person. If it's going down gradually, it's not a shock to the system when the child's in utero. That's amazing work there, right? So this is the guy who's deciding whether you're in jail or you're not, and he's allying himself with quite controversial research to save the baby. So, and one more person so this is Karen Pershing, who runs something called the Metro Drug Coalition and is helping folks access services. We had this conversation about detoxification and the relationship to punishment, and this is what she said. She said, so if they need to reinitiate MAT post-delivery, that's maintenance therapy, let them do it, put them back on it. but at least they don't have a baby with NAS and have all these systems coming at them. Because I tell you, we deal with these women. If you have NAS baby, you got DCS, child welfare, taking them to court. You've got all these people coming at you, and they're trying to get their lives together and get in treatment and all that. Personally, if I have a substance use disorder and I'm worried about somebody taking my baby, I want to wean because I don't want all those people in my life. So again, you have, right, the decision is not what's best for mom, what's best for baby, what's best for the family long-term. The decision is, how do I avoid this punishment system, right? So I'm going to stop because I'm probably out of time. But this is just this piece of care and proximity and punishment. It won't surprise you at all. At the end of the book, I talk about disentangling systems. I think probably what Professor Godsoe is about to talk about around abolishing particular systems, shrinking particular systems, and building care and achieving reproductive justice. But that's what I'm going to share for now. If I can figure out how to stop sharing.
Thank you so much, Professor. That was really interesting material that you presented. And like you just said, I'll now just hand it over to Professor Godsoe. Take it away.
Thanks so much. So I'm also going to share, which might take me a minute, but I first wanted to say thank you so much to Jinjin and Danica and the LPE folks. And my co-panelists. This is really exciting. And I also feel like we have so much like sort of synergy between. Okay, now I'm trying to share my screen. Okay. Great. So it's not really working that well. Sorry. I'll do play from start. Is that better? Yes. Okay, great. So yes, like Wendy said, I'm going to talk about like a particular group of mothers. So I think all of us are talking about ways that mothers or female caregivers, I guess even more broadly, are particularly unsupported in society. And I think COVID has really made this even more clear. But I'm going to talk about sort of a similar group to Wendy, but nationwide, which is a particularly unsupported, even demonized group of mothers who are involved in the child welfare, or from now on, I'm going to call it the family regulation system, learning from Dorothy Roberts, who's been a huge pioneer in this field. And I really argue that it's parallel to the criminal system. It's sort of the female analog to the criminal system because it is mostly mothers. It's almost exclusively low income and very disproportionately women of color, particularly Black and Native American. And I've had lots of debates with people about which is worse, the criminal system or the family regulation system. They're both very terrible with a lot of racism and punishment, but I think the family regulation system, I've concluded, is even worse because it is less known. And part of my, what I say is my job here today is to make it more known to people. And then it's seen as more legitimate because it's about helping children and protecting children, and who could be against that, right? But again, I don't think that's really what it's about. When we look at the history and the way it actually plays out, is it's really about racialized social control. But just to give some background, because again, a lot of people, even people who know a lot about the criminal system, just really don't know the system. It's very hidden, partly in the name of family privacy, but again, working against the families involved. So these kind of things that might be pretty regular, if imperfect parenting behavior, like smoking weed or sending your kid in dirty clothes, spanking them with a belt or a wooden spoon, missing therapy appointments, are all things that, in my opinion, pretty much every parent does. Having worked in the system and now being a parent myself, I literally believe no parent could withstand the scrutiny of the system. But the thing is, only a subgroup of parents have to, and they're basically exclusively low-income women, and then some men too, but definitely more women because women are more tasked with caregiving and more responsible, and then very disproportionately women of color. So all these things come from real cases where people risked having their children removed, sometimes even removed for these kind of things. And it affects millions of families every year, right? So these numbers are all down from the high of about 15 years ago when it was almost twice as many, but 3.5 million children, so millions of families, are investigated every year. And let me be clear, the investigations are like no joke, right? They go on for a month, they talk to your coworkers, your neighbors, your child's teachers. So first of all, they often find anything, if anything's there. They look in your fridge and count, what alcohol's there, what food's there. And only 16.7% of those were found to be maltreated, right? And they're really scrutinizing for that, but even the investigation alone is harmful. The vast majority of these reports, so 67%, come from state workers. The biggest group is teachers, then law enforcement, then social services and medical professionals. There's ample research showing that not only that they report disproportionately over, even controlling for everything else, families of color and low-income families. But also they're often tasked with helping parents. And this is where there's so much overlap with Wendy's work, because there's so many stories or cases from students, from my own work in the past and so on, where people go to get help for domestic violence, for mental illness, for substance abuse, for their child's disability, and then get reported from these state actors who almost exclusively look at it in a punishment way for these kind of families. And again, there's so much overlap with all the panelists' work, but this really relates to when Julie Sook talks about the history of valuing women's caregiving. Again, it's only ever been a certain kind of woman that we valued their caregiving, and certainly not poor women and women of color. And then we have, almost half, or 420,000, and this is a low, in foster care at any one time. So it's more than that, because that's just at one time, who are churning in and out, 500,000 kids. And let's be clear, here's just some more, that a lot of them are not with family members. These are the 2019 figures. There's 1% who are runaway, that meaning that the system's lost them, over 4,000 children. They don't know where they are. And very disproportionately Native American and Black. And let me be clear that foster care, no matter what is going on in the home, and I'll talk about that in a minute, because a lot of these families do have material needs that are being unmet, but foster care produces terrible, terrible results, literally on every single parameter, whether it's unemployment, homelessness, trauma and mental illness, criminal exposure to the criminal system. Every single study is that kids who have been in foster care do worse on every parameter. There's the only major study of children through the foster care system by an MIT economist. So like a legit study found that children would be much better off if they stayed home, even in homes that did not have adequate resources, right? So homes, like a lot of these homes, do not have necessarily resources, which I'll come to in a minute. So how does this all happen? Again, worse than the criminal system, which is a very low bar because the laws are so vague and allow for a tremendous amount of bias. When we talk about prudent parent, what kind of supervision would a prudent parent take? I don't know. Would people leave their 7-year-old alone? I have for 20 minutes, but again, I don't live in the neighborhood or in public housing where someone's gonna call me in. What is appropriate education? How is the parent supposed to ensure that when a lot of the school districts are underfunded, especially for kids with disability? And we see massively different rates even in neighboring communities. So between West Virginia and Virginia, within Georgia. So we see very different rates, and that's based on the culture of the agency and maybe the levels of poverty of the communities, but again, not based on actual differences in child safety. Because one thing that is clear is that the vast majority, probably 75 to 90, closer to 90% of these cases are neglect cases. So the rhetoric is always around abuse, including from professionals in the system who should know better, who do know better, and they use the rhetoric deliberately. The vast majority of cases are neglect, which means basically, back to the definitions, inadequate resources or leaving a child alone. Failure supervision is was, for instance, the biggest cause of action in Chicago. What does that lead to? Either bad judgment, like perhaps in my case, or often a lack of childcare, but not, again, a super threat, not abuse to the child. Here, they're saying a slightly lower number, 63%, and obviously these add up to more than 100% because some of them are overlapping, but we see physical abuse and sexual abuse together add up to 17%, which actually seems a little high to me, and I'd like to dig down into that. But anyway, it's somewhere between 10 and 15% max. And the rest of it is what we call neglect, which again is things that are not the abuse that people think is why kids are in the system, or why families are in the system and kids are moved. And I love this too, caretaker inability to cope. These are the categories of HHS reporting. What does caretaker inability to cope mean? I mean, I think that's probably true of almost everyone, especially during the pandemic. But again, what does that mean? And why are we, who's making these judgments? Well, they're mostly caseworkers. So again, even sort of less scrutiny and often less training than police and prosecutors and other actors in the criminal system that we think have too much discretion. These people have even more and even less supervision. So neglect is based on poverty, as even the government acknowledges. So the government acknowledges that 3 of the biggest risk factors out of like 5 or 6 for families to be in the system is a financial problem, that's their language, meaning poverty, Inadequate housing or being on public assistance, which is a very, very low level. You have to be in poverty. Again, but what do we do about it? Well, we'll see. Nothing that helps these families. Lack of childcare, homelessness, lack of treatment for mental illness or substance abuse, domestic violence. These are all things that more affluent, middle class or affluent families don't get involved in the system, partly because of bias, but partly because they can pay for these things. And so they don't, have to depend on the government. We look at the CDC, they acknowledge that or all experts pretty much acknowledge that what would make the system, or the risk factors for the system are very largely based on financial things like, primary care, strengthening household financial security, family-friendly work policies. So what does this have to do with individual parenting, right? One might ask. Again, the CDC risk factors are communities where families experience food insecurity, caregivers who are young or single parents or parents with many children, i.e. parents who are more financially stressed. And yet, although we know this very clearly, and even the government itself indicates it, we continue to spend a vast amount of money on foster care as opposed to any services for these families. And I shouldn't even say services, any material aid, because they might provide these families with services, and that's things like you need to go to drug treatment, or you need kind of the punitive drug treatment that Wendy talked about. So $8 out of $9 billion in 2018 went to foster care as opposed to any of the, families of origin. And again, we know it's not rocket science. We know again from the CDC, all experts about what would help these families, communities where there's access to high quality preschool, childcare, after school activities, medical care, economic and financial help. And I underlined this at top because I don't even like the wording of this, caregivers who can meet basic needs of food, shelter. Well, what makes those caregivers able to meet them? A lot of that is, based on class, or a huge amount of that is based on class and race. And so, the history of structural racism and other kinds of discrimination make it much harder for certain people in communities. And and also living in under-resourced communities. In addition to the huge classism and basis in poverty, there's also additional racial disproportionality. And I think, Jessica is going to talk about this, but there's no, again, it's one of those things that we can connect pretty much directly back to slavery, or in the case of Native Americans, to colonialism. And family separation has been like a consistent theme. There was a lot of attention to it recently with family separations at the border, which is a positive thing to have attention, but it also sort of leads us to forget, that it's been going on all the time for families of color in this country, and it's at every stage. So I'm just going to go ahead. I'm just going to be quick in the last part because I know I'm running out of time, but I think one thing I want to be really clear about it, and I've only come to this fairly recently, 20 years after the amazing Dorothy Roberts, but we really need to acknowledge what the system is. So just like the criminal system, it is not protecting children. It's not helping their welfare. It is a system of social control that polices and regulates families, that is racist and classist. And it is absolutely, not helping them. And like I said, I think worse than the criminal system in that it pretends to be caring. And I think for all the issues that we're talking about today in terms of women's equality and the welfare of children and families and racism, it has to be a huge priority for people. Mostly it goes very hidden because again, it only involves certain sectors of the community and other people just don't even know anything and they just think it's, bad parents. So I was very graciously allowed to use this slide from Movement for Family Power, which is, and JMAC for Families and Bronx Defenders, Family Defense, which is, there's a growing parents movement of organizing, again, sort of analogous to the criminal sector, sorry. I think it also, like with the criminal system, we need to dismantle it and then reimagine what support looks like, right? Which looks like, family autonomy, like parents should be able to choose, parents of all kinds, access to safe housing, financial stability, mental health support. It doesn't involve the government coming in and judging parents and then separating families. And I do think, to end on a slightly optimistic note, that we are in a moment of opportunity, certainly with the criminal system, and even with, some economic supports for families in terms of a lot of support for the pandemic relief, which is, partly because obviously it's based for more middle class people, but it has been sort of a cash handout, which is exactly what a lot of families need and would be far better than our current system. So I'll stop there, and I'm looking forward to people's questions.
Thanks, Professor Godsoe. Really interesting material and really thought-provoking too. Next, we have Professor Suk, who will be speaking and presenting.
So great. I want to discuss the law and political economy of motherhood as it relates to constitutional change, and specifically the century-long struggle for the Equal Rights Amendment. And as I listened to Professors Bach and Godsoe, I think it's a really interesting and important question for the ERA, because it seems like there are a lot of aspects of governmental regimes that we could identify as being sex discriminatory, and particularly discriminatory against mothers. But just coming off of Professor Godsoe's last remarks, it seems like on the one hand, you want to be able to dismantle it, but if you can't think of what's going to replace it, whether in like some form of governmental support, that's also going to be highly problematic. And so one question is, what kind of constitutional regime can we think of to deal with the complex intersection of law and political economy when it comes to parenting and motherhood? And with regard to mothers of various racial and class backgrounds who may bring different interests to the table. And I'm going to start my discussion of the ERA in the present, because this morning, the House voted to remove a deadline on ERA ratification. And just to bring everyone into that conversation, the Equal Rights Amendment is a constitutional amendment that guarantees equality of rights not to be denied or abridged on account of sex. Equality of rights under the law not to be denied or abridged by the United States or by any state on account of sex. It was introduced in 1923, but never got adopted by Congress until the early 1970s. In 1972, 2/3 of Congress adopted it and sent it to the states for ratification. 35 states ratified it in the next few years after it was adopted by Congress, but ratification stalled. And by the 7-year deadline, there was a 7-year deadline on ratification, the ratifications stalled, and so they never got to the magic number, which is 38, which is what you need to have 3/4 of the states to make a constitutional amendment. And then it's only in recent years, from 2017 until 2020, that 3 additional states ratified the amendment. And the conflict that was in Congress this morning is whether or not the deadline can now be changed retroactively by Congress so that the amendment could be added to the Constitution. The House voted yes to remove the deadline. It's not clear what will happen in the Senate. And that's part of a larger story that maybe we won't really get to tonight because it implicates many of the policies at the federal level that we might envision on this panel. In any case, just getting back to why the ERA stalled, because this whole question, should we remove the deadline, really comes to why did it take 100 years or close to 100 years for an amendment? Why did it take several generations of women for an amendment to move through the process under Article 5 to add it to the Constitution at long last? And the paper that I distributed is about the idea of productive postponement. It looks specifically at the early period of the Equal Rights Amendment, because it is a history that I think we should confront, even if we're all in favor of gender equality and gender equality in the Constitution today. And it's a history of division amongst feminists, amongst people who describe themselves as advocates of women's rights in the 1920s and 1930s. And they divided over the question of working mothers in particular, and the kinds of protections they would need in the workplace. And there were different interests at stake with regard to working class women, largely immigrant women, and white women, and professional women in the early days of the ERA's introduction. So, and the real conflict was complex because there were labor laws, including regulation of hours of work and minimum wage laws that applied to women only. And they applied to women only because the Supreme Court had been striking down in cases like Lochner against New York, had been striking down labor legislation. And then in Muller v. Oregon, upheld maximum hours laws that only applied to women. And so when the ERA was introduced, one fear was that this protection that working class women had in dangerous work, in factories, in laundries, that they would lose those protections. And of course, the protections were really kind of discussed in Muller v. Oregon as protections that women needed because they were mothers, because of their reproductive health, because of their caregiving responsibilities, right? And later on, those distinctions were cast as gender stereotypes and therefore forms of sex discrimination, not sustainable in a liberal legal regime committed to gender equality. Nonetheless, in this period, there was a fear, though, that if you got a constitutional ERA, it would lead to getting rid of protections for working women. And it was a reasonable fear because in 1923, the Supreme Court in Adkins versus Children's Hospital actually struck down minimum wage law for working women, and women's wages plummeted after that decision. And Florence Kelly, who actually opposed the ERA, pointed to Adkins, and Adkins 1923, the Supreme Court says, oh, women don't need special protections anymore because they have the 19th Amendment. So inequality, gender inequality is coming to a vanishing point, and therefore protective labor legislation is no longer needed. And citing the 19th Amendment to get rid of labor protections for women, Florence Kelly reacted to that by saying, this is a decision that protects women's constitutional right to starve. And it really put forth an important dynamic in questions about gender equality, because one way of getting to gender equality is getting rid of protections for everyone. Another way of getting gender equality is by saying if women have the protection, working men should have that protection as well by leveling up. But if you have 9 male justices who are sympathetic to businesses and inclined to level down, then it's going to be far worse for women than having special protections that are for women only. And that was a dynamic that Florence Kelly was very attuned to. In addition to saying this just protects women's constitutional right to starve, she said, we need a woman on the Supreme Court. We need more women on the courts. We should actually expand the courts. She started talking about court packing before FDR tried to do it. And it's super interesting that she did that because, of course, it's like 1923, and she says we would need a woman on the Supreme Court. And it's like 62 years later, we got a woman on the Supreme Court. But in any case, it also just shows you that this dynamic between leveling up and leveling down, it's not a theory about what the law always means. It's always what the law means in light of who the decision makers are and what their vantage point is in relation to how they understand the law working within the political economy of motherhood. And so I argue in the article that I distributed and in my recent general audience book, and for those who are interested, We the Women, The Unstoppable Mothers of the Equal Rights Amendment. So I argue in that book that the postponement, like part of the reason the ERA doesn't get off the ground is because there are conflicts between working class women and the interests of working class women and white women and professional women that really need to be worked out before you get the kind of consensus required to amend the Constitution. And so part of the reason you get more consensus in the 1940s is, of course, after the New Deal court changes its course on cases like Lochner, there's no longer a fear that a commitment to equality is going to wipe out labor law or labor protections. And also there's an engagement with the international world, the world of global constitutionalism. So after World War II, a lot of other constitutions, including France, Germany, most of the European countries include equal rights provisions for men and women in their constitutions. And what's super interesting is that a lot of these constitutions, and this is actually a pretty common feature of constitutions outside the United States, in addition to an equal rights amendment, there is a provision that says motherhood deserves the special protection of the state. And that's a direct response to, like, during war, women were doing everything. They were working and they were raising kids, and a lot of men died. So there's a recognition in the Constitution that if you actually want to rebuild the nation, you need women who are doing both caregiving and raising kids. And working, contributing to the economy. So you need women to be doing all of those things. And so it gives birth to a new understanding of citizenship that involves both what we might call private and public, and it involves thinking of motherhood as being socially valuable work. And I think that a lot of those questions are coming back now as we think about the COVID-19 crisis's economic impact and the extent to which we've undervalued the contributions of women that are not part of the market economy, specifically caregiving work that is generally not recognized as part of the market economy and generally underpaid and undervalued. And I think that is in some ways coming into our debates about why the ERA should be revived now. And I know I'm coming up on my time, so I just want to end by also transferring this idea of productive postponement. Why the ERA didn't get off the ground from 1920 to 1970 has very much to do with resolving these conflicts about working mothers. Then when you get to the big question today is why didn't it get ratified from 1977 until 2017, another 40 years. And that story also has to do with motherhood because there was an anti-ERA movement that was framed largely based on misinformation and fear about what it would do to American families. It was argued that if you had an equal rights amendment, it would destroy American motherhood, largely because it would require a rigid sameness of treatment in all circumstances between men and women. And even the proponents did not really believe that. And in fact, proponents from women in Congress from both the Republican and Democratic parties argued that the ERA was needed in part because of the disadvantages and inequalities women faced because they were mothers. And many of the proponents of the ERA were working on comprehensive childcare legislation at the same time as they were working on the ERA. And those hearings were going on concurrently. And Shirley Chisholm, who is an advocate for the ERA in Congress, Polly Murray, who testified in favor of the ERA, really emphasized some of these inequalities, even dating back to slavery, having to do with women's role and undervalued and devalued work in both biological and social reproduction, and that inequality as being central to the vision of gender equality that would inform the ERA. But because Phyllis Schlafly made the ERA a conflict about motherhood, that also caused a postponement. I don't think that the misinformation was really corrected, largely due to blockages in the political process that prevented a fair debate at the time. And I think that also shows how the amount of time it took now, as we consider whether or not a deadline should be removed, we should think of that amount of time as a productive working out rather than something that delegitimizes an amendment.
Thank you so much, Professor, and truly really timely, the things that you're discussing with the ERA and the House's resolution today. Last but certainly not least, we have Professor Weaver, who will be speaking to us.
Okay, I'm going to share my screen so that, sorry, you all can see my PowerPoint. All right, so my paper, which is a work in progress, is entitled Slavery and the Origins of Family Law. The article contends that American slavery laws, coupled with the legal and social construction of race, are core tenets of the family law canon. It illustrates that the opposite treatment of Black and white families during nearly 250 years of slavery has informed the opposite treatment of families within the family law system today. As we consider the political economy of motherhood, this article prompts us to evaluate whether the tangible private and public family law separation in the court system, is just a continuation of the marginalization of poor women, particularly Black women. I wanted to point out, as I was listening to my fellow panelists, I was thinking about the work of mothers and women, as well as wealth in this country. And so we know that recently the reports that are the net worth of a typical white family is 10 times that of a Black family. And so one of the things that this article points out is that many of the ways that we earn wealth or we inherit wealth are through families, and it's directly tied to the identity structure and status of people within the family. So the social construction of race is really where all of this starts. Slavery law defines personal liberties and family composition of African slaves as the complete opposite of white personal liberties and family composition. Thomas R. Cobb, who was a leading slave scholar of the day, describes the three great absolute rights guaranteed to every citizen by common law as the right of personal security, the right of personal liberty, and the right of private property. According to Cobb, the slave is totally deprived as to life, liberty, and property because he is under the absolute and uncontrolled dominion of his master. The opposite legal treatment of the two races regarding personal liberty is the basis for the 14th Amendment. A post-constructionalist analysis of slavery law demonstrates how the positive definition of personal liberty rights and family autonomy for whites rested on the negation of these same rights and freedoms for Black slaves or enslaved persons. The law of slavery was integral to the order and way of family life in the South during the 18th and 19th centuries. Michael Foucault's theory about society and power is illustrated by the interdependent existence of whites and Blacks as masters and slaves, and the fact that that power of the private family was normalized through law, its identity constructed and contingent on the domination of others. So here's a slide of the legal construction of families, and you'll note that slave marriages were really designed outside of law, so considered to be extra legal. They were not legally recognized, and the slaves took on the status of their mother and became the property of the slave owner. Marriage was used as both a support for the slave system and as a tool to domesticate slaves on the one hand, and then also to use as a tool of discipline whenever slaves were sold because of debt, or because in many cases, as I'll talk about later in my presentation, wives wanted to get rid of female slaves who were the concubines, so to speak, of the slave owners. Here's a quote by Thomas R. Cobb, and he talks about how slavery has been more universal than marriage and more permanent than liberty. Edward Baptiste in The Half Has Never Been Told, Slavery and the Making of American Capitalism, outlines and walks through how slavery financially benefited both the South and the North. So here's a slide that depicts the historical view of marriage, common law marriage, which is typically, at least in our books that we read, as far as history, is seen as, white families. And so in this particular slide, the construction of early family law is often viewed as engineering grounded in positive rights for white men, with women and children relegated to certain private space that was cherished as valuable. At the same time, the foundation of family law was used as a tool of exclusion and division. In many ways, the structural foothold of racism began with placing insurmountable barriers between enslaved men, women, and children as a family unit. The positive attributes of a married couple, moral, mature, and committed, was something that African slaves could not be by the virtue of their legal and social construct designed to subjugate them as less than human. So this is a picture of a Southern plantation family and a slave family. And I just want to note, that what we know based on historical research, narratives of enslaved persons, and court records is that white families and slaves intermingled in several important ways that have been ignored by family law doctrine. So in some instances, we know that enslaved women had involuntary roles of being a breeder of enslaved persons, as well as a wet nurse for white families, and also as being concubines or mistresses for their slave owners. And this is a picture of Sally Hemings, who was the mistress of Thomas Jefferson. You would note that on slave plantations, often they were sex segregated. And so when we think about women who are breeding or who are being the wet nurse, or women who are mistresses, they typically were separated from their husbands if they were allowed to have them. And so their husbands often resided on another plantation. So being a single mother actually was something that started, this family dynamic started centuries earlier than when Moynihan dubbed, Black families as being a tangled pathology, or having a tangled pathology, because they were a matriarchy or run by women. This tangled pathology that he spoke of was really created by white men in order to better control the Black women and men, and also to capitalize off of his investment. Sorry. One of the famous ways that we see this in media or in movies is sort of what we look at as the value of women. So thinking about the status of women within during slavery. And this is a picture of Patsy, who was one of the leading actors in 12 Years a Slave. And she was raped by her slave owner, who's pictured in the right. And his wife understood that that's what was going on. And there was this gendered hierarchy between them. And she did not want her to be there. In fact, she encouraged her husband to sell her, but her husband said that the slave was actually worse, that Patsy was worth more than his wife, because she was the top picker on his plantation. So she actually outpicked all of the men. But it didn't stop him from beating her. And there was an awful scene in the movie that depicted her being beaten by first an enslaved man, Solomon, and then her slave owner. One of the ways this plays out in case law is depicted by one of the historians, Lauren Stringer. I'm probably mispronouncing his name. The name of his book is Families in Crisis in the Old South. I'm sorry, I went forward. He talks about a case in Texas, actually, with within a white family, Sarah Black versus James Black. James Black was one of the richest men in Texas and had the most, one of the highest numbers of slaves, but she actually instituted a divorce against him during a time when divorce was not very common. And typically divorce did not mean that, you were separated from your husband. Exactly, it just meant that your husband was taking care of you and you lived separately. He was caught committing adultery with 2 female slaves, and actually similar to the white slave owner in 12 Years a Slave, he rebuked, or she was rebuked in front of the slaves by her husband. What we know from They Were Her Property, which is a book by Stephanie Jones Rogers, is that many white women did own slaves. And actually, some of the statistics are that divorces among women during this time, 90% of them were filed by women who had slave owning families. So they were women who had slaves given to them, and they were protected by different types of trusts that went with them into the marriage. And so this was a way that wealth was passed down, because slaves during that time were actually more valuable in many instances than the land. This case ended up with her getting $600 worth in alimony, and she ended up staying with the husband because I think the husband realized in a community property state that he would be out more money than if he kept her. So the cheaper to keep her, is definitely applicable here. And she actually died a very wealthy woman. She became one of the wealthiest women in Texas after he died, before she did. Sort of the opposite of this is a case that I found in doing some of my research, which is Henry Estate of Campbell. And I know I'm closing my time out, so I just want to end with this case. This case is a probate case that was filed by his children that were born during slavery. He was married 3 times. The court in Henry Estate of Campbell ruled that there was no such thing as a slave divorce. And so the first marriage was not recognized, but his third marriage, which was after slavery ended, was. And so his 2 slave sons did not inherit, but his third wife and daughter did. Now, he was a wealthy man in California and owned a lot of property. He was worth $100,000 at the time of his death in the late 1800s. But you can see that, all of his children did not take And the way that we pass down wealth in most cases is through property. And so there are different ways that you can see the threads of just womanhood and motherhood with all of these cases. And I hopefully will be able to explore even more once the pandemic ends and I can travel to different libraries. This is the last slide. It just basically talks about private and public family law and how on the one side you have private law where there's lots of autonomy and freedom. And on the other hand, you have public law where there's a lot of state intervention and control. And that goes back to what Cynthia and Wendy were talking about earlier. I'm sorry, Professor Bach and Professor Godsoe in their presentations, and even to what Professor Sook was saying with the ERA. I think there are a lot of ties here with respect to work, how women are even able to enter the court, and whether they're able to have access to court, and then what those courts offer. So I'll end here with this last slide. You can just look at it and we can enter questions and I can stop sharing. And thank you very much.
Thank you so much, Professor Weaver. Before we move into just the next portion of our panel tonight, I just wanted to quickly remind everyone and encourage everyone to let those questions flow. There's some percolating, I'm sure, and you're just figuring out how to put those into words, but whenever you get a chance to just drop them in the Q&A or in the chat function, and we'll get around to those before we end our discussion tonight. And so I think I just wanted to briefly kind of open up the floor and the dialogue a little bit for some cross discussion. And generally, I just wanted to make some observations about some themes that I noticed throughout everyone's time here today. And something I've been thinking through is, you know, I think just generally in America in particular, it's so intrinsically linked to the idea of care and also punishments, that they somehow go hand in hand and there's not opportunity for one and another. And Professor Bach and Professor Godsoe, I think you two touched upon that. But as well, I think I noticed some themes as well, that there's just histories of stalemate time and time again, that we cannot break from our history. We cannot break from, you know, even Professor Weaver, what you were saying, the linkage with slavery and how we see family law doctrine playing out today. And Professor Sook as well, you know, with the ERA, how it has been decades, truly decades in the making, and yet here we are today, and there's kind of been a revival of movement. And so I guess synthesizing all of these themes and taking all of that into consideration, I guess a question I'd like to pose to everyone is, like, where do you see the opportunities moving ahead, either for advocacy or implementing some of the changes and reforms that people are discussing? Where are we heading, or where can we head in these realms that you've done research and have written really insightful things on?
I can start. I have found myself like weirdly excited about the child tax credit recently, which is, I mean, I do think we're in this very fascinating moment around, like, the SEED study just came out from Stockton around the universal basic income with some unbelievably wonderful results. And we just passed a piece of federal legislation that's going to give families $300 a month per kid free, right? That's unbelievable.
Mm-hmm.
And a radical shift in social welfare provision, right? Going up to, I think, $150,000 in income, right? That is a universal benefit unlike we've seen. And so, you know, I think that, you know, I was sad when Professor Godsoe stopped sharing that slide with the beautiful images of what we need, but I saw baby bonds in there, right? Like there's a lot to fix, but money, right? Like cash helps, right? It's very, very clear that if you up the income of families, a lot of the problems that we're spending a lot of money criminalizing and throwing families in, right? Just, they really do. Economic security is, it reduces trauma, it reduces stress, it reduces insecurity, it reduces a lot of things. So I'm sort of stunned by the fact that that went through. And I am a believer that it's hard to take stuff away, right? I think we saw this with the ACA. I think once we provide benefits, people are like, oh, this is good, right? Particularly when we do so universally in whatever ways we seem to muster. So I'm feeling weirdly optimistic about that piece these days.
I'll jump in there. And I also, one of my colleagues who's a tax person, who I think is here or was here, Steve Dean, Professor Dean, and I wrote an op-ed that I'm like, I'll try and figure out how to put in the chat since I'm not that tech savvy, but about that, because I think Wendy's right, that is huge. There's never been in the US like a child tax where they actually give money to families across the board, right? It's always been worthiness, like we'll give it to war widows and whatever, and then welfare has always been hugely stigmatized, strings attached. Now, granted, Professor Dean and I did say it doesn't go quite far enough because it's not totally universal and the enforcement is very, as we know historically is very racist, but still it is huge. So I'm gonna hold on to Wendy's optimism, but also point out that a strain that has come up across the board in all of our talks, well, maybe a little less obviously in Wendy's and mine, but certainly, or sorry, Professor Bach's and mine, but certainly in Professor Dixon Weaver's and Professor Sook's is like this division among feminists or among women, which I think is really troubling and hard. And I've seen it happen where women are like, well, the parents in the child welfare system, they're like parents who abuse their kid, and part of it is maybe ignorance of like not knowing what the system is about, but part of it is always this desire to put some other group aside, right? And I do think it's really, really important, especially when we're in this moment, which I do think is a moment of change because of the pandemic and how much it's revealed about how all families are really vulnerable, given the lack of support in the US historically, for women to really group together and say, whether you use opiates or whether, whatever, that, we're all mothers are facing a lot of the same things. And that, for really to have activism together, to be lifting up even the most oppressed or most, stigmatized.
So if I could jump in on this point,
Okay.
I think there's a lot we have to think about in terms of politics. So on the one hand, I'm very heartened by some of the things that have recently passed, but also troubled by the fact that it had to be done through budget reconciliation because of the filibuster. It's going to be very hard to do lasting legislation without that bootstrap. And so I think that just speaks to who's in politics and what are the structures by which we make change. And I've been particularly attuned to this with regard to constitutional amendments because 2/3 of Congress, and we haven't done that, a constitutional amendment since before I was old enough to vote. So, because the last one was 1992. So in some ways, we like the super majority is required to amend the Constitution or now even to legislate, require the kinds of coalitions. And when there are very few women in politics and women who are attuned to these issues in politics, what it means is that things in order to succeed, and the story of the 19th Amendment and the ERA also, it's women had to convince men in power that women should vote without having the vote. So there's this structural disadvantage to getting these kinds of changes. And so I think we have to work on the political piece of it in terms of coalitions and ensuring that enough people are empowered to push this kind of legislation through. But I think we also have to recognize, people often like to vilify Phyllis Schlafly. And Phyllis Schlafly ran for Congress and lost in 1970 and never said a word about the ERA, even though the ERA was going through Congress while she was running and lost. And then she discovered that by talking against the ERA, everyone would pay attention to her. And she's kind of like a world historical figure because of her opposition to the ERA. And I think that we have to think about all the ways in which women in politics are rewarded for undermining the interests of women. That was also true when the Shepard-Towner Maternity and Infancy Act was proposed in the early 1920s after the 19th Amendment was passed, which basically reduced maternal mortality and gave grants to the states. So I think those are some of the issues that I think we need to work on.
I would say maybe two things. So the thing that I think about first is education, from K through 12 to college to law school. One of the deans, Danielle Conway, she's the dean, I think, at University of Penn State, DIxon. She and two other professors just wrote an article about, how to have an anti-racist law school. And I think part of us changing the narrative and changing laws is educating the students that are in our schools, so that it's not just the students who see this panel and think, oh, this is my wheelhouse, I love law and political economy. It's actually everybody who is getting this education and learning about, economists. And sort of a second issue tied to that is really diversifying the people who are teaching. And I have gotten sort of attuned to who are the African-American economists and what are they arguing for. And William Darity, I think he's at Duke, and another Professor Derek Hamilton, I think his last name is, they are proposing something like baby bonds. So kind of similar to what Professor Bach was talking about, how this is a huge thing in the tax code that is finally here, really only because of the pandemic, but it is really a huge windfall for mothers who are trying to raise their children, and they need this money for childcare and for whatever else they need it. But this baby bonds idea, which is the idea of giving sort of a $25,000 bond to people who are below a certain, financial, I guess, level, a bond so that their child can have that when they get to be a certain age to invest in college or property or whatever. It is, akin to reparations. And I think, one of the things that sort of pull people back from that idea of giving money away to people is sort of this idea of deserved and undeserved people. And that permeates, family law and how our courts are stratified, and sort of what Professor Godsoe was saying, well, these women do this. And it's like, well, most of us are on this stratum, and there's only a certain percentage of mothers who are really, abusing their children. So I think a lot of it has to do with education, and hopefully in educating more people, women and men, we'll have a situation where just because Kamala Harris moves into the vice presidency, we lose all Black women in the Senate, that we will have more representation, and we won't have to convince men who are in that position to vote for the ERA. We will be there and we can vote ourselves.
I feel like that is a great note to end the crosstalk on for now. Thank you all so much. I apologize for the bizarre lighting where I am. The light bulb in the ancient lamp just went out in front of me, so that's what's going on. But let me look to the Q&A, and I'll ask some questions from our audience. So the first person, who's anonymous, has asked to hear a little bit of discussion about alternatives to foster care and family welfare systems. They're saying that their sense is similar to concerns with prison abolition. People wonder how we can protect children who have been and are truly being abused if we abolish the system entirely. So anyone who wants to take it away.
I'll start, but I definitely want to hear from others too. I mean, so I've been called recently like kind of I don't know, like an anarchist or a nihilist, because, well, here's my thing. I think we can, so to channel optimism, I think we can reimagine. So going back to the movement for family power slide, like, and again, even just the CDC criteria, or even the criteria that the HHS, which is relatively new, now themselves put as risk factors of financial problems, et cetera. Like, we know what families need most of all is material aid, with housing, just cash payments, food, diapers, et cetera. There have been some programs through child welfare systems called alternative response, where it wasn't this prosecution model, and they did provide aid, and they're tremendously successful. But because of going back to sort of, I think, Professor Sook's point about politics, the pathological politics, as one professor said about criminal law, are even more present, I think, in family regulation. And everyone's like, oh, maybe a child will die. So I think, again, and I'll come back to that. I'm not trying to be flippant about that. It's obviously very serious, but it's also the harm we cause to hundreds of thousands or millions of children in the name of preventing this one-child death. So we know what it takes, and it's not rocket science, and it's actually way cheaper. So someone just wrote an op-ed about housing that it'd be $700 million cheaper to put the 26,000 children who are moved to foster care for housing to provide some housing supplements to their family. So it's not only 26,000 fewer children in foster care. So we know what it takes, but I think it's not even like creative necessarily. A lot of it is material aid. On the other hand, when I say I've been called honest, is because I think if we're not willing to accept that we can't prevent every case of abuse, like we definitely can try and do what we can. And some children, I'm not going to say no children ever need to be removed, but it's so much fewer than it is now. But we can't prevent every act of private violence. That's just impossible. And if we're going to sort of pretend that that's possible in the name and then remove all these other children, I think it'd be better for the state to not intervene at all, right? So if they're not going to be supportive, it'd be better for them to just be like, fine, we're not doing anything. Because I think, the system is just creates so much more harm than it prevents. In the name of preventing child abuse, which it doesn't even do, right? Like it just doesn't even do that in its current state.
I'm going to give a very specific example out of the study that I think is a very tangible example, but it's a little wonky. The federal legislation around substance use during pregnancy and child welfare requires states to provide a plan of safe care for infants. I personally would like to see that entire federal statute go away, but during the research, I traveled to New Mexico to see a really fantastic program that's being run out of the University of New Mexico Medical School around caring for families which are in crisis, are enormous trauma, histories of violence, and need a tremendous amount of support. So the doctor who ran this Institute for Racial Justice and Healthcare negotiated with his state legislatures to locate plans of safe care, not in the child welfare system in New Mexico, but inside the healthcare system. So he takes this federal law, which virtually every other state in the nation is saying, well, plans of safe care, that's what child welfare does. And he says, no, we don't actually have to do that. We can work with insurance companies, right? And we can create plans of self-care in the healthcare system, providing the care that women and kids need, families need, but avoiding that interventionist risk that Professor Godsoe is talking about. So I agree with everything Professor Godsoe just said, but it is not impossible to build our care system separate from our punishment system, right? On the micro level or on the macro level, the money, the resources are there, but there are very few people who want to give up that punitive response, right? Kelly Fong does some really wonderful work around this, and one of the things she finds talking to mandatory reporters is that mandatory reporters are not reporting so much because the law requires them to. What they'll narrate is that they believe that DCS is a source of care, right? And they want that punishment and care, right, partnership. So they'll refer not because of law, but because of this punitive desire for care. So it's sort of motivated, right? It's like the women in my study, right? I'm going to lock them up so I can care for them. That's their reality and that's what they do. But it's not impossible to structure our society quite differently.
I just want to put in a plug for the person who asked the question. There is a conference next Friday. Well, it starts on Thursday, but it's featuring Dorothy Roberts' book, Shattered Bonds, The Color of Child Welfare, and it's its 20th anniversary celebration, I guess. I don't know if celebration is the right word, but they're basically talking about abolishing the child welfare system or the family regulation system, which is what she refers to it as. And I'm moderating a panel on next Friday at 11 a.m. EST with 4 scholars who basically are giving their ideas about how we can abolish and what that means exactly. So there's a variety of different ideas out there. And most of them all agree that it's gonna take more than one thing. So I would encourage you to register for that if you're interested. It's Columbia Law School is hosting.
Thank you all so much. I will maybe be seeing all of you at the Dorothy Roberts talk next week. I'm so excited for that. We have another question in the chat. So this person has asked about what the panelists think about the relationship between modes of surveillance and the political economy of motherhood. They're saying surveillance seems to be a common thread throughout all of your work, and how any interaction with public welfare system invites surveillance, but also that certain types of people are always just kind of deemed worthy of public inquiry.
So I'll just go briefly, and also thanks to Sarah, Principal, for putting some stuff in the chat. Yeah, it's definitely going to be a great conference if people can register and come to part of it. So I definitely agree about surveillance. And I think one of the things that's really difficult, or at least for me to sort of think through, is the notion of family privacy, right? Because first of all, it's only historically, or even currently applied to more affluent, disproportionately white families. And Kiara Bridges has a great book called The Poverty of Privacy Rights. So, there's definitely, poor families are definitely surveyed. Like I showed, the vast majority of people who call in cases are state workers. Like in New York, a big proportion of them are in homeless shelters. So the family's obviously in crisis, they're homeless, and then the shelter worker calls in a case against them. On the other hand, we know that family privacy has protected, as the prior question asked. There are cases of, real abuse, like let's say it's 10-15%, but that's still a lot of kids. And of course, intimate partner violence, which disproportionately affects women and also, queer and trans people. That's a real issue that family privacy is protected. So I find, I think it's really hard to navigate. But again, I think the state, at least as to the families that I've worked with who are, disproportionately poor, has done more harm than good. And there's also a lot of creative thinking around, for instance, domestic violence. Like Professor Lee Goodmark has a great book called Decriminalizing Domestic Violence. And let me be clear, the title is provocative. She's not saying completely decriminalize, just like I'm not saying completely, right now, I'm not saying completely abolish the system. We're saying massively, restructure and change funding to different sources to, have other supports rather than just the criminal response.
I would say, part of the reason why we have, I guess, less autonomy, or that poor families, particularly families of color, have less autonomy, is because of Supreme Court cases that, basically enable searches and surveillance as it's tied to the benefit of welfare. So whenever the state is giving out a benefit, they tie that to, oh, we can come in your home and tell you, what your family is supposed to look like. That was Wyman versus James, I believe, was a case that basically cut off a mother's benefit because they thought that she had a man there who was not who was not her husband. And if there's a husband there, then there's no, benefit that will come to the family. I'm very skeptical of a lot of the conservatives who are sort of entering the space of advocating for the end of mass incarceration, because at the same time they're advocating for increase in surveillance. And so don't bring them to prison, but let them have something in their home, that an ankle bracelet or whatever, to monitor them. And it's the same thing. I think one of the people that's speaking next Friday is talking about sort of the over surveillance of African-American families, and how that is equally destructive, that you have this sort of big brother watching over you at all times. I think it sends a message to women that you're not worthy of making your own decisions. And the minute you mess up, we're there to take your kids or to criminalize you, put you in jail. And it doesn't allow, I think, the community to help. And I think if you look back historically, especially in the African-American community, we have helped each other. And one of the things that I argue for in one of my articles I wrote about psychological abuse a while ago was about the principle of subsidiarity, and how, the person who is closest to you, the people who are closest to you, whether it's the health clinic or the school teacher or school principal, or, your church member or pastor, are typically the ones who are able to help you most. And that's who people go to for help versus going to the state. And so, although all those things are not perfect, obviously, it would seem as though if we could invest more funding in those instead of surveillance, then we could have more people who at least had the best interest of those families at heart, because they see them daily, and they grow to care for them. And they're more than just numbers, because I think that surveillance, the foster care system and the prison system are all businesses. And as long as we continue to funnel people there, a whole lot of people have jobs. And if we disrupt the job or the business of these systems, then that puts us in a position of, oh, we need to help these people. And what do they need? Services, which can be provided outside of jail, outside of the foster care system. So I think we have to really look at the economics of it.
I think we might have time for one more quick question. Somebody feel free to cut me off if we don't. But someone in the Q&A just asked the panelists to speak about the role of the family vis-a-vis the role of the state, the parents' patrie principle in child well-being.
I'll go first, sorry. But I definitely, again, I think there's just no way to get around the fact that there's, again, this dual system, like that Professor DIxon even talked about, has gone back to the birth of the nation or whatever, between public and private families. Because one of the things when I teach children the law that's always really striking to me is that the US has, compared to any other nation period, but certainly any other sort of peer nation economically, it has this tremendous homeschooling system, which is often really terrible. Meaning in many states, New York's a little better than some, but I mean, it's very unregulated. Parents don't have to teach. In Texas, for instance, I think they have to teach civics, English, and history. Like they don't even have to teach math and science, or there's very little supervision. It's often has been found to be a cover, often for families who are very isolated and sometimes abusive. But anyway, it has this very robust protections for what is usually white Christian middle class or better families, in terms of homeschooling, corporal punishment, and other areas. And then other things like when I worked with families and child welfare, people would get their kids literally removed for marijuana, dirty clothes, and uncombed hair, right? So it's crazy. On the one hand, we have parental rights that seem to me almost too extreme. I don't think you should be allowed to deprive your child of any education, because by the time they're 18, it's too late, right? Like by the time they can decide for themselves. And then on the other hand, so the state has a role, I think, definitely in ensuring some minimum level of care in terms of parents' patriae, but it's really, really misapplied in the US, so that some families have tremendous power. Again, more white, middle class Christian families, which is mostly what the homeschooling population is now. I mean, there's obviously some exceptions, and historically there were some lefty, folks or whatever, but basically now that's who it mostly is, to really deprive their children of education and socialization, whereas other families aren't even allowed to take one tiny misstep, and then the state's all over them.
Do we have more time? Are we out of time? We're out of time.
I think we have time for a quick answer if you have.
We have time, Professor Weaver.
I could just say ditto to everything Professor Godsoe said. But, one of the key things that I think is important for, I guess, law students going forward, thinking about jobs after law school is, access to courts for poor people in general, and the fact that we have more people who need attorneys who then can afford attorneys. And so part of it is, part of our role is trying to figure out, how can we get better representation for poor women in court who are fighting the state? Because typically the reason why the middle class families and the upper middle class families are not in these courts is because the assumption is that they can get all the help that they need, and also they lawyer up. And when Child Protective Services sees a family with a lawyer that they know can out-lawyer the prosecutor or the DA, then they back off. They completely back off, and they find services, they dismiss the suit. And they don't really do that for poor women, even who are appointed attorneys, because they think, oh, well, we have the upper hand because we have the child. And so I think when states think that they can provide a better home, and who couldn't with all the money that goes to foster care, like Professor Godsoe mentioned, they can win, and they're incentivized to keep those kids in foster care and incentivized to adopt them out. So I don't know that child well-being, at least as the state defines it, is really what child well-being is. And I think part of that is sort of disrupting what we know is best for kids. And typically it's best for them to stay with their parents or with their family. But I think a lot of that is sort of changing how we provide legal access to women and men, because they are involved as well, who need the best representation. And it does matter to have a really good attorney in the courtroom. So I will just end there and hope that all of you all will choose public interest.
Can I just add something to that, just super quick, because I think, it's a really good note to end on, to think about professionalism and to think about what that might mean, right? So there's the Center for Family Representation in New York is one of my favorite organizations, right? And they have very robust teams that include liaisons for the family, social work support, but all governed within confidentiality, right? So so support can come without those breaches, right, that make families vulnerable, but can be part of their defense. And the criminal side, and on the family regulation side, zealous representation and professionalism can go a long way for particular families. Same in the medical field, right? People who are very serious about their medical ethics look at disclosure quite differently than your run-of-the-mill folks on the front lines. So super important to think about all those things.
So I just want to say, just quickly, I think that this range of solutions creates some interesting puzzles, because on the one hand, I study constitutions outside the United States that have explicit provisions about the state's role in raising children. That the state is a partner with the parent in the German Constitution. The state can ban private schools if they exacerbate disparities based on the income of parents. So you have a very active role for the state as compared to the US, where we have this notion that families are a private matter. But what I'm hearing from all my co-panelists is that there's disparity, there's discrimination. Some people have privacy and others don't. So we could take an anti-discrimination approach and say everyone gets the same level of privacy. But if we do that, it might mean less state support for things that people who are lower income need. On the other hand, if we say more state involvement, it could end up meaning a very paternalistic state that might be resisted. So I think it raises this kind of institutional puzzle that we need to think through.
And with that, I think there are no remaining questions in the Q&A function either. So I'll just kind of quickly summarize our time here today. First of all, I want to thank you so much to our esteemed panelists for coming and speaking and sharing your insights. We're so grateful for your expertise. Truly, I think everything has been so provocative, but I think also inspirational too. I think for someone who's really interested in family law and family defense work, I think there's just so much work to be done, and I'm excited to see the opportunities ahead. I want to thank the LPE project for hosting this panel and just the series of entire events that have been going on virtually, unfortunately, but hey, we're making do with what we can. And I just want to thank as well the audience for your participation and your engagement, and Danica as well for co-moderating with me. Thank you. Is there any other final housekeeping business that I need to mention or anything like that, Raul or Caroline?
Not from us.
Okay, perfect. So that being said, thanks again to everyone for coming, and we're really grateful for each and every single one of you. Thank you.